Alexander Watt for Neil and Elizabeth
Good
Anderson.
afternoon, Attorney Watt.
Good afternoon.
Christopher Sendi, representing a number of neighbors to the wind turbine.
Good afternoon, Attorney Singh. Attorney Duffy.
Frank Duffy, Town Council for the Town of Fallmouth, on behalf of the town and the town board, whoever else is called. Yeah.
All right, well, I certainly have had a chance to read the appeals court decision. I know that the judgment after rescript was issued by Clerk Nickerson, and then some pleadings were filed by Attorney Watt on an emergency basis, and then the matter was scheduled for a hearing today in Boswell Superior Court. So, Attorney Watt.
Thank you, Your Honor. I trust you do have the town's response.
I do, and I've read it.
In page 2 of the response, Attorney Duffy says, Superior Court judgment after rescript has been issued, is now in full force and effect. The town of Fallmouth is in compliance with the judgment after rescript. Attorney Duffy says, Superior Court judgment after rescript has been issued, is now in full force and effect. The town of Fallmouth is in compliance with the judgment after rescript. No amendment of the judgment after rescript is necessary or warranted. So the factual basis on which the town predicates that is a June 11th letter issued by the building commissioner of the town of Fallmouth, directing the selectmen to apply for a special permit.
That's from Mr. Gore. I have it, and I read it.
Yes, Your Honor. Now, Mr. Gore's letter, he was aware of the appeals court decision. It was really predicated on footnote 10 of the appeals court decision. And that footnote, and it's a footnote, Your Honor, that is not the direction of the appeals court. The appeals court remanded this matter to this court to take a decision consistent with their opinion.
Well, it said, where new judgment shall enter consistent with this opinion. Let's read it quick carefully. Where new judgment shall enter consistent with this opinion. And that did not require this court to do anything. It came to the clerk of the court, who then issued a judgment after the rescript without even it coming before me. There was no hearing on that. You weren't present. I wouldn't do it ex parte. So I had nothing to do with the judgment after the rescript. Let's be clear about that.
Okay.
And then footnote 10, and you can certainly contest that statement, but I wanted you to know that I didn't even know a judgment after rescript issue because it does not come back to me. I was the judge certainly on the opinion, the zoning opinion, and the appeals court said, no, we need a special permit. Okay, we need a special permit. I fully understand that, and that's the call that the appeals court made. I certainly stand by that for sure. And now the process has to unfold the way I see it. But I did not issue the judgment after the rescript. That was issued by the clerk of the court in compliance with an order from the supreme beings, namely the appellate court of the Commonwealth of Massachusetts, not by me. And then in footnote 10, the appeals court said, we, meaning the appeals court, declined to consider the request of the plaintiffs, and I don't fault you for asking, one of you did or both of you did, right? In order to the town to cease the operation of Wing 1 until a special permit is issued. They declined that.
They did, Your Honor.
Okay, I'm sorry, go ahead.
As to your first point, Your Honor, I don't know. I haven't researched whether the clerk can enter the judgment. I think it's still an order of this court for which the judge is ultimately responsible. And it is a judgment, and we're properly here on an order to amend or a motion to
I
amend.
have no problem with you being here. I just wanted you to know.
No, I
There was
understand.
no secret proceeding that took place where I said, oh, okay, Clerk Nickerson, let's issue this judgment after rescript. It happens as a matter of course.
I understand, Your Honor.
I didn't know the appeals court took action until I read about it in the Cape Cod Times. Nobody tells the judge anything. I mean, I read about it, then of course I read the decision.
So Your Honor just read the first sentence of footnote 10.
I did.
And that's where Mr. Gore stops. He's inferring from that statement that what he is required to do is he is supposed to order the town to issue a special permit. He completely neglects the second sentence where the appeals court explains itself. We're not going to do it. In this instance, that's the job of the building commissioner in the first instance.
Right.
Well, we now know that Mr. Gore did not do that. He stopped at the end of the first sentence.
Well, he's the enforcement officer.
He's the enforcement officer.
Sure.
I would like to submit to Your Honor, whether that order of July 11th was inclusive or just a partial one.
June 11th.
June
Let's
11th.
keep our dates straight. Today's July 9th.
If I may submit to the court, I did a subsequent request for enforcement, which was sent to Attorney Duffy as well as. On the top there is actually Mr. Gore's response to my request for enforcement. And my letter requesting enforcement is attached there too.
Can I take a moment and read it?
Yes, Your Honor.
So you asked him to issue a cease and desist order, correct?
Correct, and inclusive of that was Win 2, but that's not before the court today.
And he refers you back to the June 11th letter saying, I instructed the town manager to seek and obtain a special permit, right?
Yes, Your Honor.
Okay. And what is it that you want me to do?
We're asking this court to include in its judgment a cease and desist order to the town that it cease operation of Win 1. The bylaw clearly provides that no structure or use shall be made unless in conformance with the bylaw. The appeals court has determined that this structure required a special permit before construction even began, much less use. So for 5 years, it has sat there operating unlawfully, and it's just inherent in the language of the bylaw that a cease and desist order no use should be made. And Mr. Gore is the enforcement officer for that. And we know now, because of my request, and because of his June 11th letter, that he's just simply not going to do that. If you read the June 11th letter, it goes into, in fact, a great deal of legal discussion about the applicability of certain bylaws, what the special permit will be, what bylaw provision will apply, whether it's the grandfather provision or the new provision. He's taking a legal conclusion that it's the old provision. And by his failure to issue a cease and desist order, he's granting a special permit de facto. He's sitting in place of the Zoning Board of Appeals, anticipating that a special permit is a foregone conclusion. It's far from a foregone conclusion, and we all know how long special permit processes can take. In the meantime, the town has done the minimum absolutely necessary. They've had this use for 5 years. It's unlawful. We're not asking that the turbines be torn down. We recognize that they may try to apply for a special permit. But in the meantime, the use has to cease. It's prohibited under the bylaws. The building inspector is not, or the commissioner is not going to issue a cease and desist order. I think this court should issue an order, an amended judgment. I don't think it requires remand, cited in my papers, where the conclusion is clear. Remand is not necessary. This court should vacate the judgment, enter a new judgment, ordering a cease and desist of the turbines until a special permit is
So
obtained.
you want me to do what the appeals court said they would not do? Is that right?
This court has the express authority to do that.
What authority do I have to do that?
We have the authority under General Law, Chapter 48, Section 7, under Section 17, to enter such orders as the court deems.
That wasn't even before me in the underlying action. The underlying action was upon the interpretation of the zoning bylaws, which I interpreted it to be that a special permit wasn't required. And I wrote a decision on that. I didn't even contemplate anything about shutting down Wing 1. That wasn't even within the purview of the papers.
It was, Your Honor, it was a specific request, a remedy requested in the complaint that these turbines be ceased, that they stop. That was a specific remedy to annul the decision of the zoning board of appeals, overturn the decision of the building commissioner, and
Right, I'm
order.
saying, I get that. And the fact is that I didn't do that. I said a special permit wasn't required. The appeals court said, oh, yes, it is, and then said, I'm not going to entertain any order to, quote, issue a cease and desist order. That's best left to the zoning enforcement officer, in this case, Mr. Gore, correct? That's what they said.
They didn't say best, they said in the first instance.
In the first instance, yes.
We now know what the first instance
Well,
says.
in fairness to the town, the 30 days hasn't even expired yet. It was June 11th, and today's July 9th. But I'm sure Attorney Duffy's going to say that in a minute.
Yeah, I was handed a copy of the special permit application today.
I haven't seen it, so I'm just guessing that's what he's going to tell me.
I'm just
having-
Your Honor, I would just ask this court to recognize the unique situation here. We've got a town. We've got a town zoning board of appeals. We've got the town building commissioner. We've got judge, jury, executioner all wrapped into one. And we've seen nothing. We've seen evidence of nothing but the town doing the absolute
Let me
minimum.
ask you this hypothetically. Assume the town applies for a special permit. Assume the town grants itself a special permit. Is that still within the purview of this litigation, or is that going to infuse additional litigation that's going to come as a result of that? You see that within the four corners of this case?
I think I see it as a separate case.
I do too. That's why I'm asking the question. What's your position on that, Attorney Senator?
It's a separate case, Your Honor, and that's the danger. Are we going to act today in a way that sets up the next 4.5 years of litigation?
There's nothing I can do about that if in fact the town decides to apply for a special permit and they grant themselves a special permit.
Yes, but this matter starts and ends with the zoning bylaw. And the section on special permits is very clear. Part of that process is a careful analysis of negative impacts. And seated behind me are 11 Fallmouth residents who live near Wing 1 and Wing 2, and they've been working at this for 5 years. How can a structure run when that analysis, which is required in the bylaws, has not yet been done? So I understand that there are legal remedies, whether the permit's granted or denied, some party's going to come here, and then it can go on to the appeals court and so forth. The question is a simple one. Given the determination of the court system and the fact that the people on the local level have an inherent conflict of interest. This is a town-owned turbine, and we're looking at actions by the zoning enforcement officer and the ZBA. And the question is, given that situation, is it better for this court to step in and say, wait a minute, if we start and end with the bylaws, and we look at 17 and 179, and we carefully evaluate whether or not a machine with 7-ton blades should be allowed to continue to spin without a special permit, I think there's a real life to this question, and the appeals court didn't know that Eladio Gore, the zoning enforcement officer, would take a position that I will not turn these turbines off unless I get a court order to do so. And that is what he has clearly stated.
What do you say to that?
Your Honor, you know that I filed an appeal of the June 11, 2015 order. I had no choice, even though my hope is here, not in front of the ZBA on July 23rd.
I'm not aware of that. How would I know that?
I think it's in the paper before you that the ZBA has scheduled a public hearing. Attorney Duffy has indicated that in his opposition to today's motion. So there is a public hearing scheduled on my appeal. And Mr. Gore responded to that hearing. And the last sentence is.
And that's in these papers?
Pardon me?
I have that in these
You
papers?
have this document in these
Let me
papers.
see what you have. Show it to Attorney Duffy first. And you're saying that that was filed in connection with Attorney Duffy's? Was that filed in your response, Attorney Duffy?
Your Honor, I've never seen this document before, and I apologize for that to the court. I'm not identified as a CC on this or the other document.
I misspoke.
I never saw the document either because it's not in Attorney Duffy's response, so.
Your Honor,
I don't have it.
I misspoke. I submitted it, not Attorney Duffy. There is a document dated July 3rd addressed to the court, and in bold letters, it says hearing scheduled for Thursday, July 9th. I'm assuming that I sent this on July 3rd, so I'm assuming it's in this
Well,
one.
if you sent it and it didn't come by way of a pleading, it wouldn't be docketed until such time as either I say so or Attorney Duffy had a chance to respond to it. So if you sent something in ex parte, it's not before me.
Well, it was sent to the clerk with a request to be added to this file, and it was emailed to Attorney Duffy on the same day.
But that's not part of the record that I have before me today. Have you seen this document, Attorney Duffy?
I did see
Here
that
you go, Attorney
document.
Singh. Okay. All right, so this document that you just handed me, dated June 26, 2015, I've never seen before, but I see what it says, but I've never seen it.
Okay.
It's not part of the pleadings that I have before me today.
I'm sorry, Your Honor.
You know I read everything before I
I
take
know you
this
do,
bench.
Your Honor. I'm sorry.
It's all right.
What happened in this case, if I can just direct the court to how this got here. When Attorney Duffy prepared an opposition to today's hearing, he decided to copy the court on my appeal to the ZBA. Again, I had no choice but to appeal the June 11th.
I have no problem with appeals, that's not a problem.
Okay, but he didn't submit my entire appeal. He left off the supplement, and he left off Attorney Gore's response to my appeal. So I wrote on July 3rd urgently, with a certified letter, sending this to the court saying, hey, if Attorney Duffy is going to add my appeal to this file, I would like him to add the whole thing. And by the way, if Mr. Gore on the last page has actually responded to my appeal, I'd like this before the judge. If I did that in a way that isn't proper, I apologize.
Okay, so what Attorney Duffy gave me was Exhibit 4. You've seen this, right?
Yes.
That's the beginning of your appeal?
That's the beginning. He left off the 4 supplements to that appeal.
All right.
And I thought that was unfair. He didn't consult with me about submitting.
Let me hear from
one part.
Attorney Duffy.
Your Honor, if I may just address this last issue. I submitted the appeal that Mr. Cini made to the Board of Appeals for the sole purpose of showing the court that he has appealed to the Board of Appeals. That was all. The substance of his appeal, I think, is beyond the scope of this case. So I'm not trying to mislead the court in any way by not submitting the entire package, which is quite a bit. I just want the court to know that there is an appeal pending before the Board of Appeals. And if I may go on, Your Honor, I just want to follow up with the import of the judgment after rescript. Of course, you know the appeals court decided that a special permit was required. So shortly thereafter, the building commissioner The appeals court also said that they leave the issue of the cease and desist order to the building commissioner in the first instance, which is something we've already discussed. So on June 11th, the building commissioner issues an order to the town of Fallmouth, and it contains 3 things. And a copy is with my plea, Your Honor. He ordered the town to apply to the Board of Appeals for a special permit and gave him 30 days to apply. The town of Fallmouth has applied to the Board of Appeals for a special permit. I did so yesterday. I hand-delivered it. It was accepted. I have copies here at the court meeting. The second thing is the building commissioner made a determination that the 2010 zoning bylaw, which is the date when the building permit issued, was the one that applies. And the third thing is he declined to issue a cease and desist order. Now, following that, Mr. Cini, being on top of things, filed an appeal to the Zoning Board of Appeals of that decision of the building commissioner, and he has brought into question all of the issues in that appeal. And that matter is now scheduled for a hearing before the Board of Appeals on July 23rd, which is 2 weeks from today. And by the way, as we know, it's in the state law, it's in the zoning bylaw, the Board of Appeals has the authority to do any act that the building commissioner has. They have the authority of the party from whom the appeal comes. So the Board of Appeals conceivably could, I'm not saying they will or they won't, but they do have the authority to issue the cease and desist order that Mr. Cini has asked, and he's brought the matter before them. Now, there was a comment here by Mr. Watt, I think it was, or perhaps it was Mr. Cini, but how the town of Fallmouth is acting as judge, jury, and executioner here. I want the court to know that we have addressed that issue, because it is something that came to my attention. And we, as a public body, I think it's important that everybody knows that the proceedings of the town board are above reproach. I went to the Board of Selectmen, and I instructed them, basically, to authorize the Board of Appeals to hire special independent counsel for all of these issues that are coming before them. And you'll hear about another one in a minute. As a result, the Board of Appeals has hired independent counsel, and I can tell you who it is. It's Mark Bobrowski, who's the author of the handbook on land use planning and a professor at New England School of Law and a renowned authority in zoning bylaw. I personally called him and informed him of 2 things. One, that there was no limit on the number of times that the Board of Appeals could contact him. They could ask him for 1 opinion or 10 opinions. It didn't matter. And he could give them any advice that he thought was appropriate under the law. So when we go before the Board of Appeals, these folks over here will have attorneys. I or someone else will be representing the town of Fallmouth. The Board of Appeals will have independent counsel, independent of the town, to help guide them through this process. That is something I think was very important, and I think it's important that the public know and understand that. Because we want to make sure that everybody is comfortable with that there's nothing going on behind the scenes. Now, as Mr. Watt started out in his remarks, we don't think the judgment after rescript needs any amendment whatsoever. The matter has been remanded to the Board of Appeals, but this is not a situation where a remand to the Board of Appeals is an empty or unavailing event. The Board of Appeals, well, first of all, a wind turbine is not a prohibited use in the district. We're in a public use district, and a wind turbine is a permitted use by special permit in the district. So that by going before the Board of Appeals and asking for a special permit, the town of Fallmouth has an opportunity to cure the zoning defect that this case is all about. The Board of Appeals also has the authority to grant conditions on this special permit that address all of the issues that have been raised by the plaintiffs in this case regarding noise, location, interference, anything else. And they can impose conditions on this special permit, and we're going to have to accept them. There was a previously granted special permit back in 2008 where the board imposed very strict conditions on the operation of the wind turbine, and we don't expect to be treated any differently. So the remand will allow the town to cure the zoning defect. Now, in terms of the cease and desist order, there are a number of things that a building commissioner can do to enforce the zoning bylaw. One, he can issue fines. Secondly, he can order a party into compliance, or he can issue a cease and desist order. But as the appeals court noted in its footnote, this is discretionary and it's the first call, or the call in the first instance of the building commissioner. So we have a situation here where I think a remand consistent with the judgment after rescript to the Board of Appeals is an appropriate remedy, and it's not a hollow or an empty event. Something will happen, and it's possible, and maybe likely, I don't know, that these folks will get the remedy that they're looking for there. That's really what they asked for in the beginning. Now, when I filed this application for special permit with the board yesterday, I was given 2 dates to commence the hearing. One is August 20th and the other is September 3rd, and I informed both of my brother counsels here today that which days would you like? We'll set it up for a date convenient for you. So this is going forward on 2 prongs in front of the Board of Appeals in the next 2 to 4 weeks. And I think all these issues are going to be addressed there. Hopefully there'll be a resolution there, but I don't think amending the judgment after rescript is appropriate.
One thing I wanted to just refresh everybody's memory about was that in the 24-page decision that I wrote on June 18, 2013, I wrote the following. Although the plaintiffs credibly testified that they had experienced health difficulties and other negative quality of life impacts from Wind 1, the law precludes this court, that was me, from considering those impacts and reviewing the Zoning Board of Appeals decision, because the Zoning Board of Appeals authorized Wind 1 without requiring a special permit. This court has no occasion under the law to consider the factors such as noise, vibration, health, and other adverse impacts on the neighborhood as set forth in the zoning bylaws. Rather, judicial review under Chapter 40A requires this court to confine its analysis to proper legal interpretation of the bylaw. That's what I did. So I just want to make sure that people understand that my analysis was only interpreting the bylaw vis-a-vis the special permit. None of what you talked about in terms of the impact and the requirements now that are required under the special permit, which will be the subject matter of a separate action if in fact it's adverse to your clients, will come back before me or any judge of the Barnstable Superior Court. So I just want that to be understood by the folks that are here, that my decision had nothing to do with any of the factors that would now be the subject matter of the so-called special permit process. All right?
Your Honor, I think my clients do understand that you didn't rule on whether or not it was distressing.
I did not. I made a legal call, and the appeals court said, nice try, you're wrong, send it back to the appeal, to the town, and that's what the judgment after rescript does. But go ahead, Attorney Sam.
Well, I got somewhat sidetracked on this one document that I may or may not have submitted properly to the court. I draw you to the final sentence. In all matters relating to Wind 1 and Wind 2, it has been customary and consistent practice of this department not to take any action until such time as a determination/order has been made by the court. I don't think the appeals court knew when it wrote footnote 10 that a lot of your board had that position, or that belief that he shouldn't take action unless a court orders him to do so. This is the same official that had professional staff come to him back in May of 2008 and say, sign here that this is your interpretation. This is a town-owned turbine. The town of Fallmouth did a great job of trying to succeed where Fairhaven had failed. But they did intentionally skip a step that even their own engineer said was essential. And the problem is that we know, all of us, that this will lead to new litigation. The ZBA will make a call on my appeal. It may make a separate call on your remand down. And frankly, on that remand down, I don't know whether we need a supermajority vote or not. On my appeal coming up to the ZBA, I do. And I don't think these 11 citizens should have to go through another ZBA process where they have to hit that high benchmark. I think they've earned their supermajority vote, but you've got a town that is kind of bollocksed up in its ownership of the turbine and trying to protect it and keep it running. It's already constrained at night. The building commissioner made what I thought was kind of a silly argument that he can't issue a cease and desist order because of Judge Muse's injunction. That injunction restricted operations at night, but didn't insist on or require operations during the day, nor did Judge Muse know that they were illegal structures at this point. But it still all comes down to the Fallmouth zoning bylaw. the sections of the bylaws that I've recited don't allow a structure to continue without a special permit if the legal system has said you needed one. If it's a restaurant in a residential zone, it's not, it shouldn't operate if the bylaws require a special permit. The special permit process will be undertaken, it will be robust, and it will have a result. And it will likely lead to a Chapter 40A, Section 17 appeal, and perhaps further appeals. The question is, do these 11 citizens and some of their neighbors live with these turbines spinning during the daytime where there is continued distress? Linda Okagawa is here and she leaves her home. Every day it's a bad wind day. There's shadow flicker every Sunday morning, every sunny morning, and the town has not mitigated the shadow flicker impacts in the least. There is real distress still caused during the daytime under the injunction. Should it spin? Should Wind 1 spin as an illegal structure? And I think before the court says, yes, let's let the ZEO make that call in the first instance, or remand it to the ZBA, where we don't even know by what vote the ZBA should make further action. I don't even know how that, I don't know if it's a public hearing or just a work session. I don't know if it's published in the newspaper. I know nothing about how the ZBA takes this back. And I think Your Honor does still have jurisdiction. The town made it an intentional decision back in 2008 to skip a process. They wanted to succeed urgently. Renewable energy is terribly important to the Commonwealth, so I understand the enthusiasm. But an important step was missed. And I think at some point, the legal system ought to take responsibility to avoid a constant recycle. We could be 10 years down the line before we know for sure if there's a valid special permit for Wind 1, and we're queuing up Wind 2. Wind 2 is exactly similarly situated. Same turbine, same design, same size, same zone, same bylaw that it came in under. And it's not before you. We're not asking you to make a ruling on Wind 2. But look at our job. We've asked the Latio Board to cease it now that we have the decision of the courts. We've appealed a refusal to the ZBA. I don't know which way the ZBA will go. I didn't get a supermajority last time. I may not get a supermajority this time. Someone's going to be unhappy and bring it here. And for how long are we going to subject these 11 Falmouth citizens to the distress that they feel every day? So I think some extra concentration on how do we get out of this circular distress that we're in, and see if in remanding it, because of the bylaw, because of 240.17 and 241.79, there really is only one acceptable solution. Nobody's asking to take away from Attorney Duffy or the town of Falmouth the opportunity to cure. Yes, it would be wrong for this court to order that the turbines come down until they've had a fair opportunity.
What authority would I have to do that under the current structure?
You wouldn't. And there's a Falmouth case involving someone by the name of Haddad, which stands for that process. Until you give a property owner an opportunity to cure, you shouldn't order that to come down.
That's why I reacted to your statement.
Oh, did you know that case? Yeah. So we're not trying to ask you to go in uncharted territory in order that it come down. They will make a good faith attempt to get this permitted. We don't think it's possible because the bylaw has changed. We don't think the legal opinion that Mr. Gore put into his...
I'm sure the composition of the ZBA has changed since this all happened.
I don't know. I mean, I don't even ever, when I go into a ZBA hearing, I never try to consider who's on the board. I try to make the best case I can make. But should I be obligated to hit a supermajority where I failed once? Is this really where the court is going to send us? After what we've been through to get that former vote turned around and made into a supermajority, now I've got to go back and do it again. So I think the court should take a very, very close look. Thank you.
And I just have one follow-up.
Yes.
The town faces the obstacle of the supermajority and getting a special permit, so it's not really any different than the burden that Mr. Cini faces. But I also want to point out to the court, I mentioned, I believe, in my brief, that this, of course, is not the only litigation regarding Wind 1. There is a nuisance case under the zoning bylaw that is coming through this court. It is presently due for a pre-trial conference on the 14th of August, and it will be assigned for trial at that time. So, and that is the case in which Judge Muse issued the preliminary injunction. So all of these issues, with all of the testimony of all of the witnesses on the exact issues that you discussed a few minutes ago, Your Honor, is coming before the court very soon, and that's another opportunity for the folks here to get the relief they want. I just don't think it's appropriate in this case at this time. Thank you.
Your Honor, if I might just have a final sum. There's a lot of obfuscation with a lot of these other suits, and those suits will handle themselves in due course. What's happening here is that we know the appeals court has said these are unlawful structures. They required a special permit prior to construction. I can't imagine a case that screams out more for a cessation of use. If you've got to place yourself back in time before these even existed. The state of the law was that these turbines needed a special permit to be constructed. They've gone on unlawfully through the town's construction of them, and Mr. Gore's issuance of a permit for them. It was wrongful. So they wouldn't have been operating, and they shouldn't operate from here on forward. It could be 10 years, as Mr. Senni said, when we work through the special permit process and the appeals and subsequent appeals of that. And in the meantime, they should not be allowed to turn. And I think it's appropriate for this court to order that. If the court is so inclined to remand it, I would suggest remand with specific instructions regarding the expectation that there be an order to cease and desist. It really comes down to what Your Honor thinks the correct thing is, not what Mr. Gore thinks, because Mr. Gore is not going to issue the cease and desist.
I am not going to superimpose my view after the appeals court has directed and the judgment after rescript has remanded it back to the town. So with respect to whether or not I have the authority to impose a cease and desist order, I'm not making any decision on that today. I can tell you that right now. With respect to the process that's been put in place in all these papers, which I haven't seen until the three of you started passing up things that are happening as the days and minutes go by, I'm happy to see that things are progressing rather expeditiously. But I'm not in a position to make a judgment call at this particular moment in time with respect to a cease and desist order. Doesn't mean that I wouldn't. I will if I think I should at the appropriate time. That's about all I'm going to say about that.
May I ask a question of the court?
You may.
Will the court retain jurisdiction of this?
I am retaining jurisdiction. It's my case.
I wasn't sure how that would work after remand, whether we develop a whole new case or not. But if the court
No,
retains
I'm
jurisdiction.
happy to do it. I'm familiar with it. I'm not shy about issuing orders, Attorney Watt, and I will do it if I have to. So the town's well aware of what this court will do if it's put in a position to have to make the call. If I think a cease and desist order should issue, I'll issue it. And I think Attorney Duffy knows that, and that's why I'm happy to hear that the town's taking it serious. So let's let the thing progress a little bit more. I'm here 12 months this year. You don't have to chase me up to Plymouth. May take a couple of days off in July and August, but I'm here. All right?
Very good, Your Honor.
Thank you all for your appearance here today. Attorney Senni? Yes. I'm going to give you back these papers, and Attorney Duffy, because they're not part of the record of today's proceedings, so.
Is there a way in which I can correct?
Yes, there is a way, and I'm not going to discuss that now, but an afternoon motion session. So thank you.